I am Jerry Reichman. I teach international IP and copyright law here at Duke, and I have the pleasure to introduce the next speaker, who is Jonathan Masur. And like the judge before us, I thought this was a wonderful paper, very clear and very free, using law and economics in the right way without a lot of impeding jargon, and very clear. So he is going to talk to us on cost-benefit analysis at the PTO, which has come up a number of times. He's a graduate of Harvard Law School. He was clerk to Judge Richard Posner, and now teaching at, it was the deputy dean, as I understand it, and now teaching at the University of Chicago. And this will be followed by a comment from my longtime friend and colleague and co-author, Rochelle Dreyfuss, Pauline Newman Professor of Law at New York University, who has...
New York University.
New York University, sorry, what did I say?
I said New York Law School.
I'm sorry, New York University, sorry. And she has a long and illustrious career. And she was a clerk for a judge on the Supreme Court. She was a consultant in a number, in the Federal Court Study Committee. And she has done wonderful work on a number of committees that the National Academy of Sciences put up to investigate this area. We have also another representative from the National Academy here, and she's done marvelous work on these various reports that they have put out. So without further delay, let us start with the cost-benefit analysis at the PTO. Jonathan Masur, the floor is yours.
Thank you very much, and let me just be the latest person to thank Melissa for organizing this terrific symposium, for the Duke Law Journal editors for putting it together, and to all the other participants whose work has been tremendously interesting. And I'm one of the many people who sort of learned from Artie and Stewart in my earliest days, and I feel like it's great to get to be able to present a paper at a conference that they're also participating in. So I think the true title of this symposium is the lack of intellectual property exceptionalism in administrative law. And so this paper is very much right in that vein. The Patent and Trademark Office is part of the Department of Commerce. It's an administrative agency, just like so many others. And as a result of that, it's bound by all the same rules as other administrative agencies to produce cost-benefit analyses when it engages in major economically significant rulemaking. Now, the PTO, of course, so famously does not have substantive rulemaking authority. It has issued lots of rules throughout its history, most of which were sort of relatively more minor, procedurally focused rules about the conduct of proceedings before the PTO. But when the American Invents Act passed in 2011, it gave the PTO authority to issue rules that had a greater impact. So for the first time, the PTO had authority over its own fees, and also now it had these really critical proceedings, particularly IPR, but also covered business methods and PGR as well, and it had to devise procedures for those sorts of things as well. So that's what I'm interested in looking at. I want to look at the fee-setting rule that the PTO promulgated in 2013, and then also the rule governing with rule-setting procedures governing IPR, PGR, and CBM review from 2012. And I want to look to see whether what the PTO is doing when it does cost-benefit analysis, or if it is doing cost-benefit analysis for that matter in the first place. So to the best of my knowledge, the fee-setting rule from 2013 is the first rule for which the Patent and Trademark Office has ever conducted a full-scale cost-benefit analysis. I'm very excited to learn if there are others that I've missed. I just haven't been able to find one. And I thought it was interesting to examine that rule, maybe with the primary goal not of deciding whether the PTO got it right or wrong, but as a window into how the PTO thinks about patents and understands how patents affect the economy and how the PTO thinks about its own role. Okay, so here's the PTO fee-setting rule. It's going to raise fees such that it generates almost $14 billion in fee revenue over a 5-year period, 2013 through 2017. And it has a set of goals. These are the sort of stated goals of the agency. Number 1, to encourage patenting. Number 2, to improve the operations of the office, by which it mostly means lower the amount of time it takes to get a patent examined and granted. And then lastly, it has to pay for itself. It has to fully fund its own operations with its fees, not more than that and not less. So the PTO solution, the the sort of decision that they arrived at was to raise the application fees. I should say I feel like sort of embarrassed presenting my own paper after Judge Moore did it. I feel like she should be up here doing it. I'm certainly not going to do as well as she did. Their solution was raise application fees, but keep them lower than cost. So try to hold application fees down as much as possible, and then make up the shortfall with higher back-end renewal fees. So after 3, 5, 7, 11 years, when somebody has to renew the patent, make those fees much higher to cover the budget shortfall, so we have a sort of lower barrier to entry and then higher barriers somewhere down the line. Okay, so the PTO is supposed to do a cost-benefit analysis of this rule. So how does the agency think about the costs and benefits of these sorts of fees, fee levels, and of patents more generally? So when the PTO talks about costs, it thinks of the cost as, number one, the cost of the PTO operations. If it spends $1 billion paying examiners, that's a cost. There's no question about that. I think the agency is exactly right on that front. And then secondly, the PTO saw any delay in granting a patent as a cost. Every month that goes by when someone doesn't get their patent after they've applied for it, that's a cost. That's some benefit, some value not realized. The flip side is the benefits are really just the flip side of that. So the PTO saw more and faster patents as uniformly a benefit across the board. So anytime somebody got a patent, that was a benefit. Every time somebody got a patent in 18 months as opposed to 21 months and therefore had 3 more months of patent lifetime, that was a benefit. The more patents enforced, the more people getting patents, the more patents in existence, the greater the benefits as the PTO understood it from that rule. So how does the PTO understand? Granted patents equal valuable benefits, and any delays in granting patents or any reduction in the number of patents that get granted, that's a reduction in benefits, or put another way, costs. Okay, there's a big problem with this. The problem is, of course, that patents are valuable to their owners. It is surely valuable to own a patent to whomever it is who owns that patent, but that's very different from saying that patents are valuable to society. A patent is a private property right, and that property right confers some benefits, it creates some sorts of incentives, but that doesn't mean that it's necessarily good to be handing those property rights out to everyone else walking around in the world. Patents are only socially valuable if they create incentives for innovation. Judge Moore points out the disclosure function of patents as well. I think that's a very good point. I think most patent scholars would say that the incentive effects of patents are the sort of primary first-order motivation for granting patents, and that disclosure is second or third order. But I think Judge Moore is right that I should spend some more time focusing on disclosure, and I certainly will. On the other hand, of course, patents are costly. There's deadweight loss from patents. Every time you give a patent to someone, you create a monopoly right, and then they can price the good that they're selling that's covered by that patent at a monopoly price, and that can create deadweight loss if people can't afford the good when they might have purchased it at a competitive price. So those are costs from any of these types of property rights that are granted. There's also the problem of patent thickets. It's expensive if you are a new entrant into a field to have to comb through hundreds of thousands or millions of patents and figure out which ones you have to license and which will be relevant to your business. There are anti-commons problems. If you want to make an iPhone, there are tens of thousands potentially patents that cover that iPhone, and if you want to try to sort of license any number of those patents, it's an incredibly sort of procedurally costly, sort of high transaction cost environment. It's very expensive, so it just, again, makes it more costly for people to try to do follow-on innovation to produce products that are based on those patents. And then there are other sorts of restrictions on downstream research. In some cases, the patent holder will just simply prevent someone else from doing research or producing a product that's based on the original patent. So granting patents are certainly not costless. They create all of these sort of well-known, well-understood additional economic costs. And the PTO didn't seem to understand any of these things. It just saw patents as an unalloyed, unqualified good, not understanding that there has to be a balance. The balance with patents is the dynamic incentive effects that they give people to innovate versus all of these sorts of static costs that they impose in terms of deadweight losses and thicket problems and the like. Okay, so because of all of this, there are plenty of good reasons to believe that in some cases fewer patents might be better than more patents. And in fact, if the PTO were to increase application fees, the patents that wouldn't be filed for under those higher fees might be the least valuable patents. So if the fee goes from $10,000 per patent to $11,000, and some people drop out and stop filing patents. Well, the people who stopped filing patents are the ones who thought that their patents probably weren't worth more than $11,000. The patent's not worth more than $11,000. It's hard to say how much research it's actually encouraging or what function it's playing that's beneficial to society. It might just be yet another property right that's going to gum up the works for other people who are trying to do things. So the problem here, as I see it, is not necessarily that the PTO got it wrong when they set these rules. It's not obviously the case that they should have had much higher upfront application fees, and I certainly don't think it's the case that they should have tried to have lower renewal fees. I do like higher renewal fees, as Judge Moore does as well. The problem is that the PTO doesn't seem to understand what the social costs and benefits actually are. And if it doesn't understand what the social costs and benefits of patents really are, then it can't possibly think about what sorts of rules to set in any kind of organized, coherent, or accurate fashion. So I can't say for a fact that the rule that the PTO promulgated is wrong for additional reasons, which I'm about to get to, but what I can say is that they just don't seem to be thinking about it in at all the correct way. And that is, I think, a disturbing thought, not just for these particular rules, but just for all PTO operations that are under the auspices of the people who are writing these rules. We want the PTO to be a sound steward of the patent system. We entrust them with a lot of authority. I and others have even argued in the past the PTO should have more rulemaking authority, and I think that the fact that the PTO doesn't even seem to understand these fundamental, foundational ideas about the costs and benefits of patents, which are surely not original to me, but have been written about many times, that casts doubt on all of those efforts. Okay, one last thing I want to say about this rule, which I'm going to skip over pretty quickly. Even on its own terms, the rule is sort of arbitrary because the PTO could have increased application fees more or decreased them more. It might have gotten fewer initial applications, but less pendency because it could have raised a lot more money that it would have then used to issue patents more quickly. One advantage of the new PTO rule, the PTO thought, was we're going to reduce the patent pendency from 21 months on average to 18.8 months. It could have done that even more aggressively by raising fees even more. So you'd have some sort of trade-off between the number of applications filed and the amount of time each applicant has to wait before their patent is granted. We can't know whether that trade-off would have been beneficial or harmful without quantifying the costs and benefits involved, without doing some sort of calculation about whether it's better to have fewer patents but have them enforced for longer. Again, this is under the PTO's way of thinking about the world. Or whether it's better to have more patents but have them enforced for slightly less long. The PTO didn't even attempt to quantify any of these costs and benefits, contrary to what they're supposed to do under executive orders. The PTO just sort of did it qualitatively. And without any attempt at quantification, we can't know the answer. Okay, now I'll say something very briefly about the IPR and PGR and CBM procedures as well. So the first and critical thing to say was there was no cost-benefit analysis of these new procedures. The PTO thought that the rules were not economically significant, which is to say less than $100 million impact on the economy. Now, what's in these rules setting IPR, PGR, and CBM procedures? Well, lots of procedural rules about filing times and briefing lengths and all sorts of things like that, which may or may not actually be dispositive in cases. It might just determine, how much more attorneys have to work and how much longer, et cetera, et cetera. But it also had one bit that was extraordinarily important, I would think, for a lot of these cases, which Judge Moore already referenced, which is the broadest reasonable interpretation language. The PTO announced in this rule that it was going to use the broadest reasonable interpretation of claims when evaluating patents challenged in IPRs, contrary to the Phillips standard, the sort of best interpretation standard that the district court uses. I don't know whether what the PTO is doing is right or wrong. I don't know whether it's better to use the BRI or worse. I think that's a very complicated question. But I do know that that's going to make a difference in an enormous number of cases. It's surely going to have an impact on how many of these cases are decided. And it doesn't take very many patent cases to go one way or the other before you have a $100 million impact. There are lots and lots of patent cases, patent IPRs pending before the PTO, which by themselves probably have a $100 million impact on the economy in one way or another. Surely, so any one of those that has its outcome changed by the adoption of the broadest reasonable interpretation language, that's enough to get over the $100 million threshold. Certainly a handful of them in combination will get you way over the $100 million threshold. So I don't understand why the PTO didn't think that this rule was economically significant, or why OMB and the sort of central administration allowed the PTO to make that claim. And it makes me, again, wonder about whether the PTO understands the impact of its own choice of BRI, and whether it understands the impact that that will have on patents in general and the economy. The PTO, by the way, when it was calculating the economic impact of this rule, it only looked at the change in administrative costs. How much extra will people have to spend getting applications ready to be filed and litigating IPRs? Nothing beyond that. Okay, so how to move forward? I think it's unfair to sort of criticize without having some idea of where to go from there. So I guess I wanted to do sort of a very, very brief back-of-the-envelope sketch of how I think one could have done a cost-benefit analysis of the PTO fee-setting rule. So compared to the status quo ante, the way things were prior to this new rule, prior to 2013, the new PTO fees were expected to produce, over the course of 5 years, this is from the PTO's own data, 70,000 fewer patent applications than you would have had under the old fees, 60,000 more newly granted patents because they're getting to them so much more quickly. They'll be able to grant many more in that time period. And 85,000 fewer patent renewals. And if you take those two numbers and put them together, you get a net of 25,000 fewer patents in force. And then you might add to that this reduction in pendency from 21 months to 18.8 months. That was the goal. One of the goals of raising fees was to reduce the amount of time that a patent application would be pending. And then $2.359 billion, approximately $2.4 billion in additional costs that the PTO would be spending. So that's the delta from the new set of rules. That's the change that will occur, good or bad, costs and benefits. All right, so we can talk about the effects on innovation. It might be that there are decreased incentives to innovate, driven by the fact that there will be fewer patent applications. But as I said, these are going to be the least valuable applications. You have to ask yourself, how valuable would that innovation have been if the person's dissuaded from filing a patent by just having to pay an additional $1,600 in fees? There could be increased incentives to innovate driven by the fact that you get your patent faster. Now you're only waiting 18.8 months instead of 21 months. But gosh, what's the marginal effect of 2.2 months of patent life? How many people are making innovate versus don't innovate decisions on the basis of 2.2 months? The answer might be many, but I think that's at least the question to ask, and the PTO is not interested in asking that question. I suspect that the marginal effects of 2.2 months of patent life are pretty small. At the same time, there's going to be a decreased cost in future innovation driven by the fact that there are 25,000 fewer patents in force. So instead of searching through 7,025,000 patents to find what's going on in your field, you might only have to search through 7 million patents. And that might have some kind of effect as well. Other costs and benefits, well, there's potentially the reduced deadweight loss from the smaller number of patents in force, given that 85,000 patents are going to be expiring that wouldn't have expired under the old fee schedule. But you have to ask whether those patents actually covered a product that a consumer was ever buying. If somebody lets their patent expire, were they really making any money off of it? Was that really relevant in the consumer marketplace? So I'm skeptical about the size of that effect. And also you've got this $2.4 billion approximately in additional expenditures, and that's real money that could have been put to some other productive use. I believe in full employment for lawyers, but those lawyers maybe could be off doing something else with their time if they weren't engaged in these sorts of applications, these cases. So this suggests to me, by the way, Mark Lemley wrote this famous article, Rational Ignorance at the PTO, 15 years ago. I look at all these benefits and costs, and I think to myself at the margin, how great are the effects going to be of 2.2 extra months or 25,000 fewer patents? And then I look at the $2.4 billion number, and I think, boy, maybe that's really the biggest number in all of this. And maybe the lesson is that the PTO is spending money to speed up its operations because stakeholders have told it to, because that's what interested parties want. But actually, maybe we'd all be better off if we just cut the PTO some slack and said, take your time and don't worry about it. Nobody's in that big of a rush, and tried to save some money as a result of that. So I think in the end of this, just from, again, this is a very sort of back-of-the-envelope sketch, it might be that the strongest effects are the effects of thinning out the patent thicket and the effects of the administrative costs. So maybe what you want are very high back-end fees, but also maybe ask the PTO not to rush so much, you don't impose such deadlines on the PTO, and don't force them to move more quickly. In any event, the point being, this I think is the way to think about conducting an actual cost-benefit analysis where you really try to set patent fees so that they achieve something useful. And this is the way, of course, that any legal scholar or economist would tell you have to think about patents. The PTO, it seems, is doing something very different. I'm done.
All right. My turn? Okay. No, I do not have any slides. And I don't have anything to say because Judge Moore already said it all. So anyway, I want to thank Melissa and the Law Review for inviting me to this conference, and especially for giving me this paper to comment on, because CBA is, I think, a new exercise for the Patent Office. It's not something that either the Patent Academy or the Patent Bar has thought very much about. And in fact, the PTO noted in its regulatory impact analysis, the RIA, that no timely comments were actually made in response to the submissions. So it was with great pleasure to see that Jonathan, who has chops in both patent law and CBA, has taken this topic on. This is just an incredibly interesting paper with so much to cover. I thought I'd look mainly at this fee structure issue and Jonathan's critique of what the Patent Office did and what he says it should have done. I was also going to talk about post-grant practices, but I think Judge Moore, I'm not going to talk about that. In fact, all I have left are basically the nitpicking things, because you mentioned all of the others, and I'll repeat some of them for emphasis. So let's start with the argument that by counting grants as benefits and delays as costs, the PTO made two fundamental mistakes. First, what he calls in the paper the glaring error, unaccountably missed by OIRA, of using private value to measure the social benefits of patent grants, and second, completely ignoring the costs imposed by patents. On the benefits side, the observation that social and private value can diverge significantly is, of course, completely indisputable. But a close reading of the PTO's analysis suggests that the critique is a tiny bit overstated. So to start, the PTO is not quite as opaque as suggested. With the exception of the paragraph actually quoted in the article, where the PTO did seem to conflate private and public benefits, the PTO has actually used the term private value throughout its analysis. So it was fairly clear what they were doing. And it provided, admittedly implicit, but they did provide some rationale for using that method. So the RIA discusses patents with high private value as the ones most likely to create incentives to innovate and to commercialize new and better goods and services. According to the PTO, these high private value patents are also the most likely to serve as signals in the capital markets, form the basis of new industries, create more and better jobs, facilitate disclosure, et cetera. Now, to be sure, some of that is highly debatable. As both Jonathan and the PTO note, there are other ways to appropriate returns from innovation. Some of these benefits could have been realized without patents. Still, I think the PTO's approach has something of a grain of truth to it. And in some ways, its equation of private and social value is kind of article of faith, not just in the sense that the PTO takes a consumer service perspective, as you mentioned in the piece, but rather in the sense that the president and the majority of both houses of Congress see things this way. After all, the AIA was called a jobs bill, or as the Supreme Court put it in Masur against Stein, IP is intended to grant a valuable, privately enforceable right to afford greater encouragement to the production of works of lasting benefit to the world. So it's not really that surprising that OIRA would accept this analysis, partially wrong though it may be. As to costs, the PTO really did engage in boggling less analysis. I did a Google search for words like dead weight loss and patent thicket and holdout, and they never appear. And in some ways, what they did do is, I think, even more perverse than Jonathan suggests. It actually recognized that some costs are imposed on competitors and new entrants. So it mentioned the difficulty rivals have in determining freedom to operate and figure out with whom they must negotiate. It also mentions the problem of deciding what to negotiate about when the scope of the patent is unclear. But instead of considering these problems of the cost of patenting, it actually included them in the cost of delay, as if they disappeared once the patent actually issues. Now, that would be true if ownership and licensing were transparent, or if transaction costs were low, and if holdups were controlled by patent or antitrust law, but none of that is true. So it's really absolutely amazing where they considered those costs. The bottom line is that Jonathan is certainly right to critique the RIA, and in some respects the PTO was horrifically wrong, but not quite as horrifically wrong, perhaps, as he suggests. And at some level, we can't blame the PTO for trying to avoid the trap of measuring the costs and benefits of patenting. That's something that the economists of the 40s and the 50s famously tried to do and were absolutely unable to do it, and so no one possibly could really have expected that. Of course, the really interesting question is what the office should have done. So we've already talked about the fact that they're operating under a set of really serious constraints. So many institutional arrangements that might produce a better cost-benefit ratio are just off the table. So the main issue is therefore how to set an across-the-board examination fee relative to maintenance fees in a manner that covers the cost of running the office. So, as in some earlier work, Jonathan would like to use the filing fee as a screen to deter some patenting. And so he argues that the PTO should have done much more to compare that approach to its actual decision, which was to set the initial fee low and offset unrecovered costs with higher maintenance fees. But I'm not entirely convinced that the methodology provided would fully cost out this approach, or that Jonathan has fully recognized the benefits in the alternative that the PTO chose. So what are the problems? First, he assumes that if the examination fee were raised, the patents that would not be filed, what I'll call the incremental applications, are, quote, the lowest value patents. Well, lowest value to whom? It has to be, the logic is it has to be to the would-be applicants. So as with the PTO, Jonathan is also using private, not social value in his appraisal of these incremental applications. Second, Jonathan assumes that even though only some patents confer benefits, they all inhibit follow-on innovation, so screening out some patents will reduce costs without affecting benefits. But not all innovation is cumulative. Some advances are what Murgis and Nelson dubbed discrete, basically dead ends, and some, like this swing and the peanut butter sandwich, are clearly non-starters. So as a general matter, not all patents actually impose downstream costs, but they all do provide disclosure, and I'll come back to that. What his screen does do is raise the possibility that some important inventions won't be patented and as a consequence won't be developed. So in his other work, Jonathan argues that isn't an issue, and he mentioned this here too, because advances with high social value will always have high enough private value to patent. But that's true only if applicants are unboundedly rational, but sadly they are not. Remember, the patent system pushes people to patent early before they have objective indicia of value. Pharmaceuticals, for example, must be patented before safety and efficacy are fully known. Electronics, before it's clear whether they're inside a standard or outside. The need to patent quickly can require entities to file before they've completely built out their inventive concepts and know for sure how to frame their claims. In the piece on screens, Jonathan relied on Dan Burke and Mark Lumley for the proposition that applicants do know how to choose. But that assertion appears in their book to be based on a survey of general counsels, and yet it doesn't appear that there was any follow-up to that survey to see if the lawyers' subjective judgments were actually accurate. In contrast, people who evaluate intangible assets for merger and acquisition purposes are not particularly sanguine about their ability to determine the value of inchoate inventions, and nor are licensing parties. There's a reason God invented running royalties, because people can't always figure out whether what they've patented is valuable or not. The literature on the Bayh-Dole Act is especially telling because universities are in some ways the paradigmatic resource-constrained inventors, and they appear to overvalue short-term relative to long-term gains, so they file on advances that might yield benefits even without patents and let go of inventions that need a lot of development and therefore protection to bring to fruition. They're also very sensitive to licensing opportunities, and so they focus on inventions where they know they can make deals and abandon other advances, some of which might actually benefit society if developed. And they're vulnerable to pressure from folks inside the institution who may not be making choices based on the sort of private value that translates into social benefits. Misses like this, opportunity costs, I guess you might call them, should therefore be counted when analyzing a high examination fee alternative. And one way to get a handle on that might be to look at data on transfer pricing in the international tax contexts. So for unexploited patents, those evaluations are very prone to error, and many countries require firms to make corrections after the market develops. So you might be able to get a handle on how big those errors are by looking there. There's another cost associated with expensive initial screens. At the margin, inventors may choose what not to patent based on how long they think they could exploit the technology in secret. And that means, so I'm another vote for these omitted disclosures really need to be taken into account. And it's worth remembering that incremental applications will always be disclosed as long as they are pending for 18 months, irrespective of whether the patent is granted or not. Another question arises from the fact that the screen seems to be tied to the cost of examination, but as you pointed out, that's a design choice too. So this goes back to Jerry's question and rational ignorance in the patent office. Devoting resources to patents that are irrelevant probably doesn't make much sense. But again, as with inventors, the PTO can't easily figure out which applications matter at that early stage. So back to the other problem. The bottom line is that we can understand what the PTO did in an entirely different way. It's kept examination costs relatively low and set the filing fees even lower than that in order to avoid losing out on disclosures and inventions that could turn out to be socially significant. But at that point, two other different kinds of screens kick in. One is maintenance fees and one is post-grant opposition. Both happen after the patent is granted, when society can reap the benefits of disclosure, and also has had time to assess the invention and the impact of the patent. So maintenance fees target the inventor and lead him to reconsider the private benefit of the invention. And as you've pointed out, it's necessary to have high maintenance fees, because otherwise patentees just aren't going to review their portfolios. It's too expensive. So I was happy to see that you do agree about high maintenance fees, but under the constraints, the only way to have high maintenance fees is to have lower examination fees, because what they have to do is just fully support themselves. The second mechanism, of course, targets the public. In theory, if a patent is important enough to cause high deadweight loss or block further innovation, someone's going to be motivated to challenge it. In practice, though, high litigation costs prevent that mechanism from working effectively, and there's the asymmetry that one person pays for the entire challenge and everybody in the industry benefits from it, and that's why Josh Lerner, Adam Jaffe, national academies all proposed cheap, speedy post-grant procedures. And I think also important was the standing requirements. So I was not so happy to see Judge Moore talking about trying to raise that standing requirement, because I think that's actually very important as part of the second screen. So the result is that patents with low private value and or high public cost do get issued, but they don't wind up lasting for the full 20 years. Now, to be sure, the PTO was utterly unforthcoming about this reasoning. If that was the theory, it should have made clear and determined the costs and benefits of shifting to the public the burden of deciding which patent should lapse and which should be given a harder look. And of course, it should have also taken into account the cost of delaying invalidation of these patents that are causing all of those problems. Perhaps it's an artifact of the PTO's approach or a function of OIRA's requirements, but disaggregating the fee issue and the post-grant opposition question, I think, wound up obscuring the way in which they interact with each other, which I think is actually very helpful. So that's just one of the many issues teased out by this really wonderful paper, and thank you again for writing it.
Well, thank you. It was very stimulating, and as I say, I shared Rochelle's appreciation of the paper. Would you like to reply before we go to questions briefly?
Or reply to Judge Moore.
Can I say 3 minutes of Okay, so Rochelle, those are really tremendously helpful comments. Thank you so much. Those are great comments. I really only want to say 2 things, I guess. The first is, you're absolutely right. The PTO uses the phrase private benefits all the time in its economic analysis of the rule, and then it just takes whatever it's decided about private benefits and incorporates it lock, stock, and barrel into the cost-benefit analysis. So maybe
I said I was nitpicking.
Yeah, right. I mean, instead of right. So maybe instead of saying they've maybe I should just describe it as the PTO doesn't know what a cost-benefit analysis is supposed to be, but whatever reason, those private benefits end up in the CBA. And then, secondly, about the really important and big points you raised about high upfront fees versus back-end fees, et cetera, et cetera. So, I think one of the central arguments of this earlier paper that you're referring to was that I don't think that there are going to be any sorts of inventions where the invention itself has tremendous social value. We want people innovated, but actually it's worth very little to the person doing the inventing, and they're not going to go forward with it if the patent costs too much. And so for that reason, I think that high application fees would be valuable. I also think that high renewal fees would be valuable as well for weeding out this thicket too. The thing I guess I want to say about that is maybe that's totally wrong. Maybe I think you are skeptical of it. Maybe you're absolutely right. Maybe I'm totally wrong, and that paper is garbage. But even if that's true, at least the PTO should be thinking about these things. They should be thinking about patents as patent fees as serving multiple purposes, patents as both bad and good in certain ways, different classes of patents as producing a lot of harm, other classes of patents as producing lots of benefits, and they're not doing any of that. So in terms of, since I'd written a paper about what fees should look like, I felt like I should say, well, maybe they should consider my theory, but even if my theory is wrong, they should at least be considering some theory that makes some sense.
Absolutely. Okay, we're going to have some questions. I have a couple of my own, and then we'll go to the floor. I had a general question. They now have an economist working for them, and how could they have made so many basic economic mistakes? I found that baffling. I would have expected a more refined approach. And the second question is this, that goes through all the papers we've heard today. With this flood of patents that everybody's talking about, are they good or bad, how is it possible that the United States is the only country in the developed world, and mostly now the developing world, that does not have an anti-blocking statute? Every other country has a dependent compulsory license. They're never issued because once you put a dependent compulsory license for blocking patents on the books, every lawyer knows they're there. They call the other lawyer and they negotiate around it. I find it totally baffling that we can't just adopt 31L of the TRIPS agreement and move on and solve some of these problems. I leave these questions, either of these questions or both, for you before we go on.
Sure. I'll just say very quickly as to the first question, I have no idea how the PTO got it so wrong. It was baffling to me as well. I've emailed the PTO's chief economist to ask him about this, but I haven't heard anything back yet. So I welcome other ideas and theories about that.
I think they didn't want to be Fritz Matchel. That's what I think.
This was under Stu Graham, not under Alan Mark.
Okay.
Yeah.
So they had Mark Shankerman advising them.
Yeah.
I don't know if you read Joshua Gann's paper on how to set optimal fees.
Yes, I did. I think I
That
did.
basically is low application fees, and you make it up or you screen on the maintenance end, with no sense of disjunction between private and social value. That's an economist who's tenured at MIT, an MIT economist.
Yeah, I mean, that just begs the question even further.
It does.
How does he
But
make
it was,
that
they had
merit?
Mark Shankerman advising them. They had presumably Josh Gans, I think, as well. So
Yeah, I mean, I know Stu and Mark pretty well. Those are smart guys.
Yeah.
It was surprising to me. To Rochelle said something about maybe the PTO just didn't want to get in. They're trying to avoid the trap of trying to calculate the costs and benefits of patents because that's so hard to do. Perfectly plausible. But the thing is, if they had done that, then they could have said, look, the cost of the cost of patents will be X and Y. We understand that patents create costs in the following way. We understand they create benefits in the following way. We can calculate up to a certain point. We can tell you what the marginal effects of fees will be on application rates. We can't take the next step and calculate the full social welfare function. So there's a limit to our knowledge, but our best guess is to do X, and they don't come anywhere close to do it.
Right,
So
yeah,
I don't know why they wouldn't have written that at least.
Okay, we have, go ahead.
I just think it's important to pursue the point that Artie and you raised, Jerry, about the role of the chief economist's office, because it was created before the AIA, so it's been around for about 10 years. And it's, on the theory that like any number of other agencies, an in-house analytical capability was going to be important to producing better outcomes, better social welfare outcomes. And if that's not the case, then we ought to know it. Are they being excluded from some considerations? Are they being told what criteria to use? Or are they getting it wrong?
Yeah, this was in the National Academy's report that Steve stewarded through, and it was, I think, one of Steve's big points, and it was actually two things. One was to actually make better decisions, and the other is to bring the PTO up to the level of other agencies for purposes of deference and everything that we talked about in the morning. So this actually goes to both issues. Yeah.
I mean, in other work, I've done a lot of looking at cost-benefit analyses conducted by different agencies, and there are clearly gaps. There's clearly divergence in how good agencies are at doing cost-benefit analysis. Like the EPA, Department of Transportation, Department of Energy, agencies that have been doing it for a long time, they're awfully good at CBA, whereas the Department of Agriculture or the Department of Education just aren't as experienced with it. They're just not as effective. Maybe the quantities they're looking at are harder to measure also. Yeah. So I'm not surprised that there are sort of these differentials in ability level. What was surprising me was just a complete sort of misunderstanding of the kind of basic economics of patents.
Go ahead, Artie.
Just a political economy point. So, there's a lot of stuff put up by the Department of Commerce and the PTO on how many jobs patents create. I'm not sure. I would tend to doubt that most of the economists who write those reports believe them. But there's a lot of political pressure to do certain things, and so it's.
That's what I meant by political.
There are plausible articles in the literature, like Joshua Gans, telling you low maintenance fee, low application fees, high maintenance fees, or higher maintenance fees. Plus, that is the most politically expedient thing to do.
Sure. I'm sure the stakeholders prefer lower
But
application
even
fees.
Stuart Grant's article he has an article about jobs, and they misstate the meaning of that article, Stuart Graham's article, in some of the things that they have written. Yeah. And he's sitting there, so it is it is deeply deep in the politics that this is true. Yeah.
A political economy story would be good too.
Yeah.
So, hand there, and then one second we'll come to you. Good. Good.
I did have a little difficulty with exactly the point about the economy, the economist work, because it seems to me your paper, someone not knowing what the economist capability is at the PTO and from whence it comes, would be thinking, to borrow some of your language, these are people who are intimidated by the prospect of doing real economics, which I think has the difficulty both of, and I think intimidating is the word you use, or I think it's not a question of being intimidated by the prospect of reaching these issues, and I think it's also not quite true that somehow there's this homegrown economist capability at the PTO that's inadequate. I think the PTO did what it was commanded to do, which is reach out to you people in the academic world for your best economist to help drive the numbers. And then if the numbers are wrong, if the approach is wrong, it might well be wrong, but I think it's not for failure of going to the very people who you say would judge the effort to have been inadequate, which really, I think is not any kind of criticism as to your criticism of the outcome, but I think it does suggest that you might characterize who is undertaking the work and what their capabilities are a bit more charitably.
Sure. I don't think I used the word intimidated, but if I did, I agree with you that was an inappropriate word. I also don't think I ever criticized the effort that the PTO put into it. I mean, these costs, the RIA is, multiple hundreds of pages. These things are enormously difficult and time-consuming to do. So I don't think I criticized the effort, but I agree with you. If I did, that was inappropriate also. So to the extent that I made any criticisms about intimidation or effort, I take them all back. I didn't mean that at all. I just think they got it wrong. And, as to who's to blame for that, you're absolutely right that they're drawing on academic studies. Already references Josh Gans's paper. Stu Graham is one of us now. Mark Shankerman is one of, et cetera. So, this isn't, right, I don't think I ever,
The blame is
I don't think I
spread.
ever said, like, there's something in the water at the Patent and Trademark Office in Alexandria that's causing this all to go awry. I just mean that whoever it is they've hired, whoever is in charge of these things, like whatever process all these people went through, the thing they wrote down just isn't correct, and it's not correct in really fundamental ways.
But that's why I think making more of the political economy story would help you.
I totally agree. I mean, it might be right. It might be that it might very well be that they just felt that they had to do this for political reasons. They
The
had to
fact
have.
that a lawyer didn't pick it up,
Yeah.
it tells you something.
I mean, I think I allude to this about the choice they had. I think they had a similar sort of arrangement of fees, of low application fees and high renewal fees, but just higher on both sides. And that was what they put in the notice of proposed rulemaking, and they were persuaded out of that by a series of comments from, the patenting community. So I do agree, and I think I acknowledge, at least to some extent in the paper, that there's a real issue about the politics of all of this. But I just don't, it boggles the mind that this was the best way to justify what they did, even given the political constraints they were
It's not
operating
the
under.
politics of being customer-oriented. It's a different kind of
No, I
politics.
understand.
It's not the politics of being customer-oriented, which is what it says in the paper. It's a different kind of politics.
Okay, so one
Speak a little louder, please.
okay, yeah. So a couple comments. One, I think just in your presentation here, you kept saying that it's a question of 2.2 extra months, and I think what some people at the PTO would say, and certainly others would say, was that it's really 2.2 earlier months, which you can imagine is going to be more significant. I know when I was in practice, you'd have some startup companies we would say, the department would say, look, this patent application, we're not going for the broadest claims. They need a patent issued quickly for funding reasons to try to start getting licensing revenue, et cetera. Of course, we'll kick out a continuation so we can pursue those broader claims later, but they need a patent now. Sure. So the 2.2 earlier months, I think, is a fairer way of characterizing it, relatively minor. I think the other point, just coming back to the intellectual property exceptionalism idea here, is I guess one question would be, is how much worse is this cost-benefit analysis than what you see being generated by administrative agencies, across the spectrum of administrative regimes? I seem to recall a presentation, I think, by Howell Jackson last year on a paper on financial regulation, where you look at these cost-benefit analysis by agencies dealing with financial regulation, you think they're fairly sophisticated, and there are a lot of things that are being fudged or, not explained, estimates that are, where the complications are being thrown under the rug. So it might be interesting to compare how much worse, say, if it is worse, the USPTO's approach is than what you see by other administrative agencies.
Okay, great. The 2.2 months point is a great point. That seems exactly right. I mean, when I said here, I don't know how important that is at the margin. That's me speculating wildly, and maybe you're absolutely right that 2.2 earlier months are really critical. In terms of comparing these cost-benefit analysis to other agencies, it's interesting you pick financial regulation, because that's another. So the SEC conducted their first cost-benefit analysis about 1.5 years ago, prompted by the Business Roundtable decision. So that's another agency that had sort of never done CBA, didn't want to do CBA, and was kind of dragged into it kicking and screaming. And yeah, that CBA is pretty poor as well. But if you look at it if you compare it, I mean, by no means do I think that EPA cost-benefit analysis is great and perfect. I mean, I've written a lot of papers pointing out flaws in it. But this, to me, it's the equivalent of if the EPA said, boy, more arsenic is always better. So let's just have as much arsenic as we can, and let's have the rules that will allow people to dump the most arsenic into the river as quickly as possible. Just a sort of complete misunderstanding.
It would be their private benefit to do that.
Yeah, right. Total misunderstanding of what it was they were supposed to be regulating or not. Yeah, huge private benefits from allowing the factories to spew out arsenic. So, and other agencies, I mean, EPA, they're getting things wrong, small things and miscalculations, and maybe they're not calculating benefits they should, and so forth. But they're not making kind of fundamental errors like that, and that's what I thought was so glaring about this.
Let me just point out in passing that, if I'm not mistaken, the UK Patent Office has quite a few economists working for them, a whole bunch of them. I met some of them. Maybe that would make it better. I don't know. It sounds like that they've just started.
EPO has a lot of people. They write crappy reports too.
Other comments, questions? Yes, okay, go ahead.
I'm
Artie,
interested
you've
in this,
already.
so you should go
So you should-
first.
It's a small question. I want to ask you about the $100 million trigger for OMB
Yeah.
review. And I'm wondering, I guess I'm asking you to speculate. I'm wondering whether you think PTO just got it wrong. Do you think PTO is trying to insulate themselves from OMB review? Or do you think OMB didn't want to review the rule and told PTO, maybe you should try to set the trigger so we don't have to do this? How do you think that worked?
It's a great question. It's hard to know without sort of injecting people to PTO with truth serum. I guess if I had to guess, gun to my head, I would guess that the PTO didn't want to have OMB review the rule, and so they claimed that it was below 100 million. OMB, sometimes they catch, agencies do that all the time. So there's actually now a burgeoning literature, a lot of it written by my colleague Jennifer No, on ways in which agencies try to evade OMB review. And the bottom line is agencies are always trying to evade OMB review, and the OMB is always trying to catch them in one way or another. And I don't know, so I think I say in the paper, I don't know how this slipped through that catch. But it seems entirely plausible to me that nobody at OMB or OIRA knows that broadest reasonable interpretation is going to actually impact the outcome of patent cases. So nobody there realizes that this is actually going to be an important and significant rule.
How did this, if you could beef up the OIRA or like OMB, like how did it get past them as well, right? So it's like one gap with what happened in the PTO, but like it's on both sides, right?
Yeah. It's a great question. I mean, again, it might be that that OMB OIRA just doesn't have expertise in patents, and so basic things about patent economics that everyone in this room knows just aren't known to OMB and OIRA because they've never reviewed cost-benefit analyses by the Patent Office before. It's new. It's just as new to them as it is to the PTO.
I actually also wondered whether it was a transition period thing. I mean, I think we pointed out during lunch that the number of, or somebody earlier today pointed out the number of cases being reviewed is really going down pretty rapidly because of selection effects early on, and the office is still learning, and maybe they just decided to let it, is this possible? They just decided to let it slide, because the next time they have to do review, it'll be much more at equilibrium.
You mean that OMB decided to let it slide as a part of the PTO?
Yeah.
It's possible. On the other hand, I mean, we don't know. It's unclear whether there will ever be another rulemaking. Under current law, it's not clear the PTO has authority to make rules that will be as significant as this one again. So
Really?
I don't know what the next thing they're waiting for is exactly. But it's possible. I mean, if what's going on here is that the PTO just doesn't quite know what they're doing, and then OMB says, well, you know what, we're just going to let it slide because you guys are doing this. That would be interesting.
Because they've
That's
already
kind of
noticed
remarkable.
a lot
if
of
it's true.
rulemaking to revise the rules of the post-grant
Yeah.
procedures. So Michelle Lee has put that on
Right.
her website that, now this has come out. So maybe they think, well, let's let the next part come
Right.
out, and then we'll see what it's like.
So they're doing lots of tweaking of the procedures, and they're also doing lots of tweaking of the fees, and none of that has ever been deemed, none of the fee changes have ever been deemed economically significant, and so none of it is going through any kind of cost-benefit analysis, and none of it's really getting review at OIRA.
Did I see?
Maybe, sorry, Michael, since he has an edge.
Oh, no, I'm good. Oh, yeah, I just had a quick question about your work with Eric. Did you see any markers indicative of learning, looking at the other agencies over time?
We didn't do a really systematic study of that, so I don't want to draw any broad conclusions, but I would say the agencies that do more cost-benefit analyses seem to be a lot better at it. The agencies that do fewer seem to be worse.
Just one quick point. OIRA's staffing, usually they have one or two people dedicated to a particular agency.
Yeah.
So one of the things that I observed when I was at the PTO was that they did have one person, but if that one person transitioned out, it's actually a very, because OIRA is very small, as you know.
Yeah.
And so if you don't have that one person kind of on the ball, it makes a lot of difference in terms of policy outcomes.
Yeah.
And that sort of stuff is, below the radar, but it matters a lot.
Yeah, I agree. And to add to that, I think there have been periods of time where they've had a person who was really a Commerce Department person. And so that person, in some cases maybe knew something about patents, and in other cases might have known something about all the other operations of the Commerce Department, but really nothing about patents.
Okay, if there are no further questions, we can close the session. Thank you for your wonderful contributions. And we move on to the next.
We are running a few minutes behind, but we have an open-ended Q&A for Judge Smith following his closing remarks. So however long say, that would be great. Thank you, Professor Rai.
So we are delighted to have a Duke Law alum, present our closing remarks. He also happens to be the celebrity of the day, really, in some respects, in that he is, of course, the founding chief judge of the PTAB and just recently stepped down from it. So all that you already know from his excellent interventions. You probably do not know his long and storied career prior to joining the PTAB, which is very similar to some of the qualifications of some of the PTAB judges that he mentioned earlier. So Judge Smith was, he worked with, he was a partner at Arnold, White and Durkee, and later the managing partner of Dewey Ballantyne's Texas office. He's been an assistant dean of Emory Law School, so I don't know how that fit into all of this, but he also spent his time in academia. And he led the in-house intellectual property teams for 3 multinational corporations, Lexmark, Nokai, and Baxter. So quite remarkable, and now he is intellectual property counsel at Ecolab. So I really look forward to hearing what he has to say about our day.
Thank you very much for allowing me to be here. It's always a privilege to come back to Duke. It was quite a privilege to be here and be a student many, many years ago. And of course, the law school is a far better law school now than it was then because of, among other things, its extraordinary increase in size of faculty and the continuing evolution of quality of faculty. I was very glad that they even let me on the campus back in whatever year it was, and feel it even more privileged now that it's a better school that they let me on the premises, much less to say anything. I think it's interesting to go back to 1787 and talk a little bit about former presidents, which actually is not as irrelevant as it might seem. In my time at the PTAB, we thought often about Lincoln especially, and from time to time, Jefferson and Madison. I'll go to Jefferson and Madison in a second because they are people who, among the things they did, spent a considerable amount of time talking about CBA. In fact, CBA is really the crux of their correspondence, which took place during the formation of the Constitution and then thereafter in the discussion about the first patent legislation. And I think it helps frame some of the context to better understand the discussion going on now, including Professor Masur's paper. But let me go to Lincoln first, who is perhaps a little less germane to some of the discussion from today. And just to give you a bit of my sense of a fond exceptionalism that exists in my mind about the patent system and the PTAB. President Lincoln, you may know, is quite appropriately right up there with Jefferson and Madison as a candidate for the title the patent president. Among other things, he's the only president who actually had a patent issued in his name, being an inventor. He's also the president who really made what today has become the PTAB. In 1861, he followed through on an act that had been passed at the end of the James Buchanan administration, which called for some number of people, 3 in particular, to review actions of the Patent Office to make possible reversals of decisions by the Patent Office. And it is those three people who formed what evolved over the course of some 152 or 153 years to what really is the PTAB, the Board of Appeals, the Board of Interferences, which then came to merge, and the Board of Patent Appeals and Interferences, which then later was seized upon by the legislation to transform into the PTAB, the tribunal we've spent so much time discussing today. One might think that the discussion today reflects some incredible new emergence of the importance of the review of patent office decisions, and that wouldn't be an inappropriate conclusion, but in some ways it's not an altogether new thing to happen that we would stop to observe the importance of a tribunal in that space functioning in that way. Again, to put it in context, when Abraham Lincoln, President Lincoln, appointed the first three reviewers to serve as a board of review for the Patent Office. It was March of 1861 that he began the consideration of the candidates, and April of 1861 when he made the appointments. For those of you versed in your history, you will recall that those are the very same months in which he was giving thought to how to handle the situation at Fort Sumter, which was under siege or about to be under siege in South Carolina, placing the issue of the operation of this type of tribunal in his daily affairs with certainly as much current time, if not as much time, as the issue of the possible division of the country. That's really extraordinary stuff to think about, nor was his contemplation of the patent system and how it might improve through the operation of such a tribunal merely one that he took on arm's length as a chief executive looking at merely one branch of government. His appointment to the position as the chairman of that board was that of a lawyer by the name of George Harding, with whom Abraham Lincoln actually had tried a patent case. So his involvement with the overall process was not merely one of executive oversight, but personal, a reach to his own personal involvement in the patent space and from his time in patent litigation that led him to the particular choice of the person who led the function. This is what gives rise to my regular resort to Lincoln when thinking about the PTAB and its daily operations, and particularly in the context of exceptionalism of the tribunal and its interaction in the overall government context and the administrative state. But Lincoln is perhaps not the most relevant president to some of the ideas that have been raised today. He's certainly the most relevant to the PTAB itself, but not to other things such as cost-benefit analysis. You will recall that when the Constitution of the United States was being hammered out, and somewhat contrary to most people's recollection of the history of the situation, Thomas Jefferson was not in the United States and not a regular participant in those discussions. His discussions rather took place by way of correspondence through James Madison, who was very intimately involved in the process, and of course, here in the United States. Thomas Jefferson was in Paris, other parts of France, serving a brief period as one of the country's emissaries to that country. And just a quick aside here, which I do for nakedly political reasons of my own prioritization. Jefferson was not in France alone. He was actually in France with, among other people, a young lady by the name of Sally Hemings, who history has treated quite unfairly. We think often of Michelle Obama as being the first African American First Lady, which she really is not. When Jefferson came back to the United States and eventually became president, his relationship with Sally Hemings was quite deep, and in fact, one need but consult the birth records of the Jefferson children to see that when he was not in Washington but in Charlottesville, there was no shortage of interaction between himself and Sally Hemings, who really was, if history were to treat her fairly, the very first African-American First Lady of the United States. Those things aside, I am still quite fond of Thomas Jefferson, whose contributions to the patent system are truly enormous, not only because of his discussion about what patents would be eventually, but also because he helped after he was back in the United States and after the Constitution was in place to hammer out the first patent acts which really made the patent system manifest itself in government in the United States. That's only one of his post-Constitution contributions, another one of them being his quite deep and seminal and monumental involvement in the system as the first U.S. Commissioner of Patents. Going back, however, to the constitutional period and his discussions with Madison, you will remember that the most fundamental part of their discussion really came down to this one essential question. Are the benefits of the patents really worth their tremendous cost? And Jefferson is particularly noted for having emphasized how high the cost is of granting to anybody a monopoly, because a monopoly, particularly on ideas and inventions coming forth from those ideas, that kind of monopoly is a truly expensive thing, so expensive to the good of the public that the initial thinking always should be to stay away from them. But Jefferson himself was persuaded in the dialogue with Madison, who more often took the other side of that debate, that although the monopoly cost was high, the monopoly cost is high, that the advantages of monopoly and reward for inventors is itself high enough to the public that we would suffer the cost to the public that results in some sort of payment or opportunity for the inventor. Now, I think just to comment again on in the context of the papers we've been looking at today, I think one thing perhaps worthy of more discussion in the cost-benefit analysis discussion is that the benefit to the patent holder is recoupment of the investment, but there is a public benefit also that comes from blocking the space, which is to say, once invention moves forward down any particular technological challenge, the first reaction is to think that that necessarily is a bad thing for those who wouldn't be able to proceed down that same channel. But I think one of the often discussed, not so much today, aspects of benefit for the public has to do precisely with that blocking of a particular channel of innovation, because it forces innovation in other channels, those channels themselves possibly yielding equally beneficial innovation or possibly yielding innovation which may be ultimately more breakthrough than the channel first blocked by the granting of some sort of monopoly right. It's a discussion certainly worthy of much time and which has robust and complex elements associated with it. And again, going back to Jefferson and Madison, I think they would be somewhat surprised if we did not today still find ourselves somewhat intimidated and perplexed by the daunting task of the cost-benefit analysis associated with patents, because so much of what that involves touches on things which perhaps are not totally quantifiable, which is to say, for example, how exactly do you measure how much money it takes to move someone into their garage for years at a time to battle upstream against doubt and bad economics, to work through some innovation that in the end transforms society. The incentive structure and the types of rewards that really move invention forward certainly need study, demand study, especially in the context of the administrative state and how we structure regulations. But at the same time, it is perhaps good to recognize a certain amount of the imponderable in what invention is and how the opportunity for rewards actually move on human beings. I will tell you also that the papers are interesting to me in the context of contemplating Jefferson and Madison because they represent and form the first milieu of some of the other things we study and talk about today. For example, when we talk about cohorts of examiners, what subject could be more Jeffersonian than that, because he was in fact the first cohort and formed the, not only formed the first group of examiners and selected the first group of examiners, but also during the course of his time in that role had changes of heart as to how much examination scrutiny should be put forward in looking at applications, deciding in the first instance that very intensive scrutiny should be applied to every application to the tune of granting only as few as half a dozen or so patents in a year, and then deciding in the face of an onslaught of maybe 100 or so applications that the standard perhaps should be adjusted, incorporating with himself in the process different individuals who then formed later cohorts working together through successive regimes of training and also decision-making about where the cutoff line would be for innovation and what kind of process they would apply in order to arrive at their decisions. I think we've also talked quite a bit about deference and things like court stacking and the like, subjects also which are very Jeffersonian and Madison in terms of where they, of how they approach issues, not necessarily in the patent context, but certainly where new questions of how due process comes to exist when courts might be stacked by chief executives. Those types of questions were not at all unseen by them, nor did they fail to have views and even battles about those kinds of subjects. I would say this about deference, and there's one kind of deference I particularly hoped would come to the PTAB during my time there, and I hope always is a feature of deference that comes to be experienced by the PTAB and afforded its decisions. I hope there'll always be sort of an inherent deference to the decisions of the tribunal based on the quality of the decisions. It is certainly important, again, to look at the administrative setup, how the law frames around the different arms of government and how they look at each other's work. But ultimately, much as Professor Golden was speaking about in the context of standards of review, after you get past the standards of review question, standards of review not being unimportant, there is the question, well, how good is your case anyway, no matter what the standards of review are. After you get past things like Chevron deference and the like, there is fundamentally this question about any of the decisions of an agency, and these kinds of fundamental questions having to do with the decisions of any tribunal. When you look at the decision itself, are the merits strong enough, stripped of every other thing like standards of review and amount of deference? Do you think the tribunal got it right? And a tribunal that is seen as getting the decision right, I think necessarily will have a leg up in the discussion as to whether or not it should be afforded deference. I also wanted to address the subject briefly of first mover versus prime mover, or first mover as prime mover in the system. I think one thing that should be clear if we were to diagram part of the clear acknowledgement of the discussion today is that, again, here I'll draw on some of my experience as an engineer and drawing flow diagrams and the like. There is, for most systems around which you might put some box in order to capture the system and through which you might put some line to capture the output, oftentimes a feedback from the output back into the system. Once you have that kind of arrangement, the question necessarily arises, well, where does the process begin? Does it begin in the system or with the feedback into the system? Does it begin with the decision or review, and what more impacts the outcome? What came out of the box, or the fact that what came out of the box is now put back into the box to help determine the outcome. I think that it certainly is the case that many parts of the administrative estate in the patent world impact what we see as outputs and influence what decisions are made. But I think there is something to be said for any agency that acts well and quickly to help define the space and determine what's going on. Here again, I will point to an example of a question I raised earlier when it comes to broadest reasonable interpretation versus the district court approach to interpretation. Let me diverge only momentarily to say this. It is important when considering these two standards also to ask this question: how big a difference is there between the two anyway? Many people would tell you that in 80 to 90% of the instances they see, the difference between broadest reasonable interpretation and the Phillips or district court standard is inconsequential. And then in the remaining 10 or 20%, it's left to be asked, if there is a difference, how much does it matter? In any event, for whatever reasons that drove the Patent Office decision to have a regulation in favor of broadest reasonable interpretation, and with that operating as a possible point of influence and outcome determinative stroke for the Patent Office, I am very much of the view that a switch to the other standard would actually enhance the power of the agency and make its decisions even more impactful to the system, because then the standard being used by the tribunal would be the same as the various district courts in the United States, and then there would be the need to have some second mover at least acknowledge that a first mover had undertaken some decision which either would or would not be followed, but would at least have to be acknowledged. I've mentioned now a range of things that we've talked about, and I've at least given a nod to the people whose framework I think I still have in mind whenever I come to these questions of the patent system. The people who sought to put into our Constitution provisions that lead to patent protection, for all the things they might have done right or wrong in their personal lives, things which might, if they had been given the light of day, led to more or less disgrace of their names, one thing is certainly true. They were extraordinarily forward-thinking about what might be achieved in our economy by taking the time to look at intellectual property and what patents might do for us. I don't think there's anyone who would suggest that the United States has not been the standout country, certainly in modern times and perhaps in all of human history, in terms of leveraging something to extraordinary innovation. It may well be that the patent system needs improvement, has within it dysfunction. I don't think there's anyone who would argue to the contrary. I think all the discussion, however, should at least acknowledge this fundamental thing. We live lives as human beings today, in this country and in other parts of the world, that have benefited tremendously from an innovation which in its character has no comparison anywhere in the world or in human history, and a lot of that revolves around having somehow harnessed the energy of innovators so that within the system of government and rules we have in place, they continue to choose to innovate. That's my 2 cents. Your questions, please.
This is a question for you, partly just as the former chief judge of the PTAB. I mean, what do you see as the top challenges for the PTAB going forward? And if your successor were here, what advice would you give to them?
Here's the first thing I would tell my successor. You are so lucky because you weren't there when I was there. And I would mean that seriously, and I will illuminate just for a few seconds some of what the challenges were in the 2011 to 2015 time period, to point to things that are necessarily would be less the focus of the next person in the job. So when I arrived at the patent office, the Patent and Trademark Office, there were actually 95 judges, not 70. There were 25 staff attorneys who had served for a long time who had become judges, taking that number from 70 to 95. That was very significant because at the time there was a hiring freeze and the board actually was not permitted to grow its number of judges for all of the previous 4 or 5 or 6 years before that time, which was a significant impediment to the board because long before it took on the trial jurisdiction brought to it by the AIA, it was handling administrative appeals to the tune of 10,000 per year. So that embargo on hiring was a significant impediment. And the move from 70 to 95 did not benefit from that embargo being removed, but the fact that the people who filled those judge slots already were employees of the agency and the board, and thus their appointment got around the embargo. But then from that 95 number, the board grew to 250, and at the time, we had one location in Alexandria. We subsequently added a location in Arlington, and then Detroit, Denver, Dallas, and Silicon Valley. So the whole D thing. And of course, the AIA came, and there was the rulemaking and all the things associated with that. Now, here's what that meant for the chief judge. 6 or 7 trips to each of 4 or 5 cities in the space of 18 months. This is in addition to the actual judicial workload, to meet with the various local officials and bar people in each of those places to, among other things, help identify judicial candidates. The successor doesn't have to worry about doing that, doesn't have to make the trips to the cities, does not, at least not for that purpose or that number of visits, would not have to do the some 36 public appearances in cities across the United States in 18 months for purposes of the proposed and final rulemaking, would not have to engage in the review of 2,400 judicial appointment applications and sitting on 600 screening interviews of final judicial candidates and presentation of nominations to the Secretary of Commerce. Nor would that person have to, sitting down for the first time with the group of judges working on the decisions, read through line by line with Blue Book in hand 150 initial determinations as to whether to hold trials and another 150 final written decisions when they came out. So being freed of all those kinds of responsibilities, the successor is in a position to do something perhaps more important and requiring somewhat less brawn and more brain. And I think it's really to give attention to the very kinds of things that have been raised in the papers today. It's not as though we didn't give, for example, Chevron deference a lot of thought during the time I was there, and particularly trying to figure out where the difference is between substantive rulemaking and procedural rulemaking, and trying to make sure that we built the case for our activities being more than sufficient to support procedural rulemaking for the later stages of review of the decisions at courts. But that work and the other work associated with, for example, fine-tuning the selection of which cases actually have trials instituted, which ones go to trial, which ones actually use the great resource, what to do in the years subsequent to this tremendous oversupply of cases. All that is now work that is ripe, that was not ripe before, with the whole range of solutions of the kind that you've heard discussed today now squarely before whoever the successor is to deal with. Just to mention to you some things that are not so apparent, one might say, well, okay, what went wrong with this fire hose of cases that are at the PTO and at the PTAB? I think part of the answer is we don't know what went wrong, but or went right, but whatever it is, it happened, and now there's a tremendously greater workload than anyone thought there would be. And it's not as though there had not been substantial predictive exercise underway to try to size the whole thing. Just turned out that, among other things, the thought that people would not believe in the capability of the PTAB was all wrong. What happened is people believed in the capability of the PTAB. And it happened in stages. In the first 3 or 4 months, 5, 6 months, 7, 8 months before a substantial output of written decisions by the PTAB, the numbers stayed low. In the first 3 months after we had a substantial output of decisions and people were reading them, the flow of petitions into the PTAB just skyrocketed. I was both very pleased and displeased with that. Pleased because I thought it clearly represented an affirmation of our work, but then left us with the tremendous difficulty of dealing with it. And by the way, just to I think, correct a statistic today. In 2015, I think the PTAB actually had more trial filings on patent matters than even the Eastern District of Texas. What happened in 2013 and 14 is, in 2013, the number of filings at the PTAB got to be within the top 6 for tribunals, which is to say, as you know, there are about 80 federal district courts, about 72 of which actually receive patent disputes to be heard. And there are a clear small minority of those courts which receive most of the filings, the District of Delaware, Eastern District of Texas being typically the two leaders, Central District of California, Northern District of California also being very high up there. By late 2013, the pace at the PTAB already had begun to be within shooting distance of all of those courts. In 2014, the top 3 clearly were just the PTAB, the Eastern District of Texas, and the District of Delaware. And I think at the close of the year 2015, the PTAB actually passed the Eastern District of Texas with the most number of filings, which, as you think about it, is extraordinary in a number of ways. It's extraordinary that an administrative tribunal, which for the first time has the opportunity to hear inter partes proceedings, ever competes in terms of number of filings with any federal district court. The other extraordinary thing is that unlike those courts, some of which have been where they are for 100 or 200 years, we had been where we were for 2 years and had to adapt to have more filings than all the rest of them. But I think it is those follow-on challenges that equally or more important that now fall to the next generation.
Hi, I'm Trevor Chenoweth. I'm a 2L here. In your discussion of Jefferson and Madison, I was thinking, what would they think about the shift in patent ownership today from small inventors, people in their garages, to large corporations? And does that change the analysis at all? Does it mean that we're more suspicious of deference to the agencies that might be captured or lobbied by those corporations?
I think that's a great question for the professors. I often wonder what those people would think about so many things. And I will confess, perhaps somewhat unusually, one of the times I think about them and how they would think about our current situation is during the first 15 minutes or so of a Sunday of football on television. Why, you ask? One of the things that happens that on coverage of football, particularly at the beginning of a day of football coverage, is this amazing thing that I tend to think of, again, really sort of in the Jeffersonian, through a lens impacted by Jefferson. And again, you'll see that even that I think that way says that I continue to have him in my thoughts, notwithstanding his sins. But what happens often, almost always on those days, is that the NFL will sort of run the gamut of where the games are. You'll see the team take the field in San Diego and in Seattle and in New Orleans. Of course, you go to New York and to Washington. If you're one of those people and you're watching this on television, first you've got to get accustomed to the idea that you're watching it on television. But then someone like Jefferson has got to be there thinking, holy cow, we did get a bargain with that Louisiana Purchase thing. Look at how big and vast this whole enterprise has become, which would reset your lens for thinking about any number of things. Not only has the country itself blown up in terms of what it is and where it is, but the different individual enterprises which comprise it similarly have, including the patent enterprise and even the way innovation is approached. And I think Jefferson in particular, having a respect for agrarian life and sort of the individual away from the massive state and government being limited in size, I think he would wonder whether, as the rules have evolved, we've taken sufficient consideration of the contribution of smaller people, smaller entities. Are the prices low enough so that they can get the patents and recoup their investment, or have we skewed the system entirely toward big entities? I tend to think that what they would say first is, holy cow, the problems are big. But I think they also would say that they are glad we are attempting to tackle them, and that they don't necessarily disagree with the way in which we are fighting towards answers. It's clear that for the problems that they envisioned and would exist and which played out in their own time, they were never all that much in agreement about what the answers should be. So hard for them to say that we should be. Time may be, no?
So, Judge, do you have any thoughts? I mean, obviously this would be based upon sort of accumulated wisdom and not necessarily statistically significant, but as you read many, many cases that were decided at the PTAB, did you have a sense of what examiners were getting wrong such they could be trained better? Like, what sort of things should go back into the feedback loop, if you will, to use your metaphor? And full disclosure, a former fellow of mine is actually studying this systematically. So, but it would be good to get your impressionistic view as well.
First, let me say that my heart goes out to examiners, and I was one briefly. In fact, before I came to law school here at Duke. I don't want to, especially since this is being recorded.
Maybe I should have asked you offline.
I don't want to say anything that would be improper or not charitable. I will offer this, and this is an observation with which, I think there is little dispute. Our system has a major problem or challenge, a major problem in it. The patent that gets litigated where the litigation costs are between $5 and $20 million, that impacts a revenue stream of maybe $1 billion, is not uniquely identifiable when it's going through prosecution, which means the 12 hours, 8 hours that are allotted the review of the application will be no different for that patent than the time allotted for the review of either the swing or the peanut butter and jelly sandwich application. There's some difference with respect to different kinds of technology, so that's not entirely true, but mainly the swing is narrow for the amount of time that's invested on the front end, and it's woefully low when you think about what the consequences are of the grant and what happens in terms of actual time investment should the patent go into litigation. Against that backdrop, it is amazing how often the patent office gets it right, how often examiners reach the right conclusion, and it therefore is hard to come up with any precise recipe, I think, for things that examiners need to get right. a list of which would be derivable from PTAB decisions. I think examiners also are, their situation merits our sympathy because one layers on top of the complexity of the technology and the limited time to do examination other problems that have to do with, for example, the fact that between the Supreme Court and the Federal Circuit, they can't quite agree on things like patentable subject matter, which is a huge issue for examiners. How do you guide them, even through PTAB decisions, to help them do a better job when what the guidance is said, at least the guidance from the Supreme Court is said even by the Federal Circuit to be difficult to follow and possibly problematically contradictory within itself. That said, I think there are at least some touchstones from the PTAB decisions that will be helpful to examiners. One of the big things that I think the examiners could take from PTAB decisions, and I think this is one of the hallmarks of PTAB decisions, actually, particularly in the area of obviousness, follow what the Supreme Court seemed to say in the KSR decision. When you're putting references together to make the case for obviousness, take the time to put together a concise statement of the rationale that drives the combination and make sure it withstands review and scrutiny. Don't leave others to guess as to how it is the conclusion was made that certain things would, in the skill of the ordinary person, be combined in order to yield the invention. I think that is one example of several things that examiners routinely don't do well enough. And it's not necessarily the failure of the ability to do it, but sometimes the ability doesn't matter. It's about the written expression of what was done that is fundamental to the work product, because ultimately the product of the examination is the statement of the examiner in the rejection or in overcoming whatever the rejection was. So I think that's at least one thing that I think can be derived from examiners, from PTAB decisions, in a way that is uniquely a function of what the trials are and what the outcome of them is supposed to be from the PTAB.
So I often tell my students that if they want to figure out where to go, find resumes of people who've gotten there and see how they got there. And I kind of just wonder, with the 2 L's and 3 L's in the room, you know, what advice do you have on their career? You know, from what you've learned, I mean, your career is just so diverse and fascinating. And I wonder if you had any advice for the students in the room about where to go from here as a 2 L or 3 L.
If they want the same fate to befall them, or or if they want to avoid it. What can I say? I have been so extraordinarily blessed in terms of my professional journey in ways that I didn't calculate and I'm not responsible for it. That would probably be malpractice for me to presume to suggest anything to anybody. I would say this, and I touched on this at the beginning, big blessing number one in my legal career was being allowed to come to this place. I sat in this classroom, and I'll confess, I don't know what you might conclude from your own visual observation. I sat in this very same room for the first time 33 years ago. and graduated from this school. In fact, this is my 30th year anniversary from graduating from Duke Law School, having started property class 8 a.m. in the morning Monday in this very room. That was a wonderful thing for me. And I think for all the things people have to say about being a lawyer and law school, I think the education of a lawyer is a wonderful thing. I wouldn't trade my time in law school for anything. I think what we study in law school, what we come to discuss, how impactful the law is in the lives of people and society, it's unmatched by many other professions. I won't mention physicians because, of course, you first have to be alive to even enjoy the law. But I think the law is pretty special. One thing that I did throughout my career, I didn't want it to be regimented. I wanted to be willing to try different things and to let the law and even intellectual property be sort of my calling card, but with the idea that those things gave me opportunities in many different environments. And I think that's a useful thing for deciding what to do. And all kinds of strange and good things can happen from there. Thank you so much.
So wonderful. And we do have some gifts for the speaker.